the prolonged detention of these people without transferring the file or releasing them, how does it affect them? Not only Dr. Besigye, even other people who are still on remand. Yes. Michael Tugende?
Yes. Human rights of our clients, Colonel Dr. Besigye and his co-accused, and also the other members of the NUP, among others. A long list of those who are detained or imprisoned on the orders of the court-martial remain unreleased and in detention without a warrant, detention warrant. It has caused a crisis which should have been avoided. The crisis started the day when the Attorney General took it upon himself, or government, to attempt interpreting the order on their own whims. The orders were very clear. The Supreme Court was very clear that the orders took immediate effect, and they were noticed to all and sundry. The Attorney General was represented ably by the Deputy Solicitor General, among others, and you saw that everyone after this decision was read was in a way willing to respect, and it was widely welcomed. We have had a few challenges since we met the Commissioner of Prisons. He said he needed the advice of the Attorney General. The Attorney General asked us for a decree from that court. The Deputy Solicitor General and team who were there briefed us that they had already given him a brief or summary of what was decided, the implications, and the way forward. Even when we believed it was not of the utmost urgency, we went ahead, extracted a decree with all the orders of court, served it upon the Attorney General, who endorsed it actually, and went to the Supreme Court for endorsement. So everything is in place, save for the willingness to abide by the law, save for the political will to respect court orders. And I will tell you, the prison's boss was very clear that we really feel uncomfortable keeping these people in prison. Just recently, we received incessant calls from prisons officials telling us to find all ways of getting at least our client, retired Colonel Dr. Besigye, from prison. We told them we've done everything under the sun. And the reason was very clear. He was too sick for them to bear. That's why they rushed him to get medical attention in a private facility. But even as of this morning, we went to Luzira. It is just one statement. We are waiting for the final nod from the Attorney General. You recall that it's the same Attorney General who lost in the Supreme Court. It is the same Attorney General who told the public for several months that he was waiting for the decision of the Supreme Court to determine on whether the court-martial would continue or not, and that he would respect whatever the outcome of that court. But it's very apparent and for everyone to see. If anything happened, especially to our client, it is very clear who will bear the blame. It will be very ugly. I call upon government not just respect the law, but respect the right to life. We have an ailing client being held without a court order, a detention order. There is no warrant that keeps retired Colonel Dr. Besigye in Luzira. He's a person who is entitled to and deserves specialized treatment, which probably may not even be available now in the country.
Last time when we talked to you, you said that the Attorney General had gone to consult the Chief Justice on the decision of court. What happened?
The Chief Justice, for all I know, did not have anything to say. The courts have been very clear. The Supreme Court has been very clear that our orders were easy to read. They were self-executing. We terminated anything about that court. There is nothing that is left with that court. We only advised government that you follow our advice. Our advice is, if you want anything about that court, go back to Parliament, amend the law, and then you can have business with that court. You cannot continue holding people on orders supposedly emanating from a court which is non-existent. The court is non-existent. The files too, actually, cannot be there. You cannot have files in a court which is non-existent. Neither can you have orders, prevailing orders, from a court which is non-existent. But I am aware that the DPP is trying to peruse I don't know what. But at least as a lawyer, I know there's nothing for the DPP even to pick. The bits and pieces of the files that were in the defunct general court martial cannot be relied upon by the DPP. Probably, if there are any charges, like it is always stated when charges are dropped, a person can be held again on fresh charges. If there are such charges, it is only under such circumstances that the DPP can start a new process of investigation with a view to prosecuting any of these people. A long list, I'm telling you, I saw the list is long. The prisons officials were very clear that we have the list here. The moment the decision was made, we compiled the list of all those who qualify, or actually who do not qualify to be here. So the list is there. It is before the Commissioner and the Attorney General. We still wait. What have we done as lawyers besides that? We've, of course, we filed matters in the High Court pending before His Lordship Justice Douglas Singiza. We believe very soon, even this week, anytime this week, we may be called upon, summoned, to go and lay our case, an obvious case of unconditional release before the court.
Okay, before I go into the details, people are asking, why do you file the habeas corpus case whereby you know where the accused is? Because they have the view that if someone is to file the habeas corpus case, it's supposed to be that you don't know the whereabouts of the person. What can you say?
Habeas corpus works on people in unlawful detention. Habeas corpus is that someone has been held unlawfully, his liberty has been curtailed unconstitutionally without being produced in court, if that is to be the case. So habeas corpus is for unconditional release. That is the prayer. And it's obvious, the moment it lands in court, no court under the sun would say that these people are in prisons properly. So the tactic is delay. The first issue was extract an order or decree out of that judgment. We extracted it. Now I don't know what else. I believe it's the Attorney General to answer, or any spokesperson of government to answer to why these people remain in prison.
People have the view that why don't you file the bail application case for starters?
No.
Do you see any need of filing a bail application?
Well, for starters, that has been overtaken by events. Because you want to release them from where? Because a bail application stands on a charge which is properly before court, that there's a pending case and someone should be released. Released on bail means you are still a prisoner. But the court has resolved all these issues. It is true, it was our intention before the court decision, upon filing a reference or filing the constitutional court, in the constitutional court, a constitutional petition, which we did file, arising out of that petition. Before hearing it, we had an application for release pending determination of the constitutional matter. But now there cannot be any pending reference out of a court or a matter which has been since resolved by the apex court.
What if the Attorney General transfers the files as they allege? Because according to you and the legal team for Dr. Kizza Besigye, including you, you want to say that you are challenging that, oh, it is not acceptable under the law, it is not what the law says. What if they transfer the files? What could be the next step from you?
The most qualified institution in as far as the law is concerned is the Attorney General. You know, when I'm talking about Attorney General, I'm not talking about my friend Chiriowa. I'm talking about a full institution. And I know everyone there at least is qualified and they know the law. I don't believe anyone would give advice thus far that a DPP, that you keep a file with investigations that have been nullified, that have been rendered void for having been taken in a wrong way by the wrong people and a wrong charge and a wrong court, being instigated by a wrong institution in as far as the law is concerned. No, I don't see them do that. All the best they can do now is to delay, just to delay the liberties of our clients. But everyone will tell you, for example, I've been giving an example of the majority members of NUP who are in that prison because of having, it was alleged they were in attire which relates with the armed forces, military fatigue of sorts, the berets and others. You can never find such a charge before the DPP. So there's even nothing to open. The DPP will not even touch because it is not anywhere within the matters or charges that can be sustained within a civilian court. So there's nothing for her or him to take, or the institution to take before the civilian courts. This is the first batch that would have been released like yesterday. Unless someone has another offense, which I believe there is none, because then did they commit these offenses while in prison? So it is very absurd. It is very ugly. The country continues to look ugly. If people died in prison under such circumstances, it is the most ugly of circumstances. We thought government and courts had at least given some hope to Ugandans that the law can apply. It can be applied and it can be done without any bias. But that the implementation stage is being taken in a very shabby way is now taking us back to even the pre-decision times when people did not even believe that these people can ever be released, since the authority that is being checked is the authority of the apex, the fountain of honor.
Do you want to say that if it is okay with, according to your submission, you want to say that it is okay for the government or for the state or the DPP's office or the Attorney General's office to charge the Dr. Kizza Besigye and other offences apart from, other than keeping them in Comingado? Is it what you want to say, in custody?
It will be, if they want to commit an illegality which has a face, that is where probably, because then that is what the law says, that someone is released unless the person is held again on fresh charges. So I'm asking myself what those fresh charges would be. Would someone have committed those charges while in prison? Because pre-decision, ante this decision, the crimes that had been committed, purportedly committed by these people, were all before courts. The same were terminated. The same were extinguished by the apex court. But we know, history has shown us that often in times, very many of our clients, I'm talking this out of experience, many of our clients who have been released by courts, false charges, trumped up charges have often been laid against them with a view to having them as what we call a holding charge, to having them held, having with a view to circumventing decisions of court. So I'm talking about this as a person who has experienced it in such matters, and I hope it is not what they are preparing for, because nothing else justifies the delay. So even rearresting them would be illegal, but I would not be surprised if the same was done. But it is even uglier that they are being kept in. It can be unlawful and unconstitutional, but if that is the case, then let them come out clear and say we are holding this, because there is no charge, there is no lawful detention now as we speak. But they are free under the law. But I've told you it's very easy for anyone to see, did these people commit any fresh charges from prison? And if charges have, for example, the retired Colonel Dr. Besigye, would you go back to Greece? Would you go back to Switzerland? Would you go back to Nairobi? Would you replant a gun there? Because everything, the chain of evidence, everything about that charge was extinguished. It was destroyed, because a DPP cannot rely on evidence of investigations by the military. So you cannot reconstruct the crime scene. So it is as simple as that. Unless trumped-up charges are brought against retired Colonel Dr. Besigye, they can't. NUP members, unless now you make them wear another attire, it doesn't make sense, because there's nothing fresh to investigate. You not reconstruct the crime scene. The DPP cannot rely on an investigation on a crime scene which was contaminated, tampered with, or handled by the military. It's as simple as that.
Okay, if I take you back, one would like to take us of Dr. Besigye, because we heard yesterday that he was shipped to a certain hospital to get medication. As the lawyer, how is his health status right now? Are you allowed to go and visit him? Are the relatives allowed to go and visit him? How is his health status?
The prisons are in panic. The panic in their voice was very loud. But now they think anything could happen. It tells you the situation. They could not handle him. They contacted family and contacted the legal team and ended up having him. Practically, someone in a wheelchair but still lifted. You can imagine, you are in a wheelchair, but again you are lifted in that wheelchair. So he's emotive. As of yesterday, he was a bit emotive. He was really in a very dire state. And I believe the government also is thinking again about this, and I hope the faster they act to rescue his life, the better.
We heard that Dr. Besigye went on a hunger strike, and that is what is weakening him more, though he may be having some issues according to his health. But we hear that he has been on hunger strike for, is it like 2 weeks right now? That is what is weakening him.
Yes.
What can you say?
Yeah, from the first day that I met retired Colonel Dr. Besigye, he said he's going to defy, for him he said he will defy the president's intention of unlawfully detaining him. So one of the means of protesting and sending a message is what he has said, that even if it means giving in his life, he has said that not once, not twice, that he is willing to sacrifice. Because it's not about him. The hunger strike is not about retired Colonel Dr. Besigye. He is making a statement against all those people who not have a voice, who not even have the space to express what he's expressing. So the hunger strike is about all those who are illegally detained. Because you will not release Dr. Besigye and leave the others in prison who are released under, who ought to benefit from the decision. So his defiance against that court was not personal. It was not him alone. So anyone who thinks it's about Dr. Kizza Besigye then has not understood what Colonel Dr. Kizza Besigye is saying as a human rights activist and a political leader.
If you talk of the charges, if I take you back, if you talk of the charges, Manya, the decision of the Supreme Court, some people have the view that according to the Supreme Court decision, these files were not supposed to be transferred, as others allege. They were saying that they were not supposed, the people who are pending charges in the court martial, their files were supposed to be transferred. According to the decision, that is what they say. And others are saying, as you as lawyers of Dr. Kizza Besigye, you are saying that this was supposed to be released. What is in between there? One would like to understand. What was the decision, the gist of the decision?
The Supreme Court, I want to look at the orders. The Supreme Court was interpreting the law. It was not a trial court. That's where people get a problem. That the Supreme Court was not the court under which these people are tried, would not give orders of release. That's why it did not give those orders. That's what people expected, that the Supreme Court would have said these people be released immediately. It said the decision handed down will operate, it takes immediate effect. That is what the court said. And what was that decision? That anything about that court, to be very precise, was wrong. Void ab initio. It means from the instant, it never, when the law was made, because we're challenging the UPDF Act, it should never have been. That is what court said. That is why it discussed whether the decision acts retrospectively, that even the first person who was charged under that law, it was a wrong thing to do. That is what the Supreme Court said. So, what then? You cannot put something on nothing. You cannot have a tree, you cannot say the tree will have leaves without roots. The moment the roots are cut, then you cannot ask for leaves. So you cannot have something out of nothing. You cannot have a file out of a non-existent court. You cannot have a file out of a non-existent investigation which has been nullified. The bits and pieces which the Supreme Court talked about are those for the DPP to look at and formulate an opinion on whether actually there can be a matter which can be not transferred, a matter which can be taken to civilian courts instead of having been taken to the military courts. When a charge is terminated or dismissed or withdrawn in criminal matters, it does not mean it cannot be reinstated. So simply the Supreme Court was saying, if there's anything that can be a criminal element or that can be sustained as a crime or a charge, the DPP should look into it. And probably if a person has been released, the DPP takes up that charge afresh, investigate it, but put it in perspective again. The DPP will not reconstruct a crime scene. The DPP will not reconstruct evidence. So it is as good as dead.
What you want to say that if a case is in court, it has to follow, do you say chronological order, how it's supposed to move from the scene of crime up to?
From day one. That's what we call probably a chain of evidence. Yes. The moment that chain is interfered with, the moment the chain is broken, the moment the evidence is contaminated, that is because it's proof beyond reasonable doubt. There cannot be any doubt about the evidence. But now it has been touched by different people. You cannot go back and reconstruct these scenes. You cannot place these people in that position. because it has to be an independent investigation by police. At law, the DPP cannot rely on an investigation that was made by the military or CMI, by military intelligence. The DPP cannot rely on it. It is very clear. It is unconstitutional. If that's to be the case, if that is what they are thinking about, we are going to challenge it. The DPP, it is about police doing an investigation. First, there is a report of a crime to police. There was never a report to police in any of these matters. Upon a report being made, then police takes over investigations. After investigations, police sends the matter to the DPP to ascertain on whether a charge can be sustained out of the evidence as collected. Then the DPP determines on whether it cannot or it deserves further investigations into the matter before a charge is drawn. So this is a process. So the clock cannot, it does not work anti-clockwise. The clock will not go back. It is not a fiction. Actually, what they are talking about would be a fiction. It would be like a movie. It would be like these investigative movies that we see, or series that you would take back. It had Colonel Dr. Kizza Besigye. Yeah? So are you going to rearrest? Because even the arrest itself, police has to participate. That if the military has arrested someone, they will hand over to police to take over. He has never been placed into the hands of police to take a statement or a charge and caution statement, because that is where it starts. So you want him to go back to police, then make a statement, you reconstruct the same person in a hotel in Nairobi, the same person in Greece, then a person with a gun. You know, it is quite complicated. It will be something new in our jurisprudence. That it will be the very first of cases in the Commonwealth jurisdiction that you can have a charge reconstructed, and that is what the DPP would be doing.
Council, can I say that is it a demand to the government, or it is a request? It is an order from you, the legal team, for these people, for Dr. Kizza Besigye and even other people. Is it a request that you want to tell the government that could you please release these people? Is it a demand? Is it an order? We
are going back 40 years ago, actually more than 40 years ago. This government, this regime came, and one of the pillars was to fight for the return to the rule of law. We are simply telling government, please, go by the rule of law. If you want to go back to Parliament and try to circumvent, it will be ruled by law. It will not be a rule of law. So it is as simple as that. There's nothing very complicated about this. It's whether the government is still willing to be seen as that government which fought for the rule of law. Simple.